muddle into practices that the citizens of the state might not want to, might be inconsistent with what regular Georgians would want. There's a number of issues out there, a number of contexts, a number of media that we're talking about, and generically we're talking about everything from fingerprints to signatures to bodily fluids, blood information, urine samples that speak to drug use and other kinds of things, all the way through DNA, retinal scan information, to tracking of individuals through RFID or other means. These are the whole range of things that would be designated as questions of biological privacy. And we're looking to address them in a holistic way, a way that embraces the harmony of opinions from both sides of issues. It doesn't have a particular philosophical bent, but that looks to, again, as we seek to be as holistic as we can be, looks at context as diverse as educational institutions, what's an appropriate level of information maintained, collected in an educational context, be it K-12, be it Board of Regents, private universities, employment contexts from public employment, private employment, special law enforcement employment. What's an appropriate level of information in a right-to-work state that a private employer can compel an employee to disclose as a condition of employment? That's one of the questions we'll ask in this committee. We'll discuss some today. One of the key environments is a medical environment. What's an appropriate level of biological information in the context of medical care, hospital care, elder care. We look beyond that towards law enforcement. In fact, the August 30th meeting focused primarily on biological privacy questions in a law enforcement context. From when is it appropriate to collect DNA information in the course of an arrest, conviction, and subsequent imprisonment? When is it appropriate to collect fingerprint information? What are the control mechanisms in place to ensure the security of fingerprints? We dealt briefly and discussed the issue of expungement. Once folks are found innocent and information has been collected, what's the appropriate process to deal with that information? Not something this committee can deal with, but something we discussed and recognized needs to deal with as a General Assembly moving forward in other arenas. And looked at, there's some other areas too from the context of public access. Access to sporting events and recreational events. What's an appropriate level of intrusion on one's personal information as a security measure for access to things from the Georgia Dome to Disney World, down to private commerce and banking? What's an appropriate level of security verification for businesses who want to protect the financial transactions, which are terribly important, and balancing that against private security concerns. Those are all things we want to discuss in this committee and make sure we've got the right folks sitting around the table having the conversation, so that as we move forward, if this leads to legislation, which it may or may not, but likely will lead to some action by the General Assembly, that it's done in a way that's has been initiated from the very beginning with a broad vision and looks to see the whole picture and not just pieces of the picture. Because so often, as you've seen, many of you spent years and years down here, when the General Assembly gets to do things, if it's not well informed and all positions haven't been considered and all implications haven't been considered, we sometimes do good things and sometimes do not so good things. So we want to make sure we're looking at this as holistically as we can. So with that, that's really the vision of the committee. Process-wise, again, like I said, August 30 was our hearing that dealt primarily with biological privacy in a law enforcement context. Today is really our biggest, broadest, possibly most significant meeting of this entire study committee, because we're dealing with things, again, as you look at your agenda, varying from real ID to medical context to education to retail and banking to public employment to research and development. So very broad meeting today. I will apologize in advance if we cut folks off and ask them to spend less time on things than they'd like to. But again, in interests of being able to deal with the issues as best we can, and we're going to have to, in some cases, limit limit the discussion. So I'd like to welcome Representative Hill. You've missed nothing, Calvin. So
sorry, I've been late. The traffic was terrible.
You've just missed me talking for 5 minutes, and you've. So that being said, we've got a sign-up sheet for individuals who'd like to speak. We've got a number of people already designated on the agenda. If you're not on the agenda and would like to speak, we'd like to afford you that opportunity during lunch. We've got a lunch break scheduled from 12:30 to 1 o'clock. That's been graciously provided by the Medical Association of Georgia. We'd like to thank you for that. And during that lunch period, we're going to have a candid, kind of open conversation. If there's anybody who's not on the agenda who'd like to speak to the committee, we'd like to give you the opportunity to do that at that time. So that being said, I'd like to call forward Chris Calabrese from the American Civil Liberties Union. Chris has graciously come down from D.C. to speak on the Real ID Act and implications for biological privacy. Chris.
Mr. Chairman, I have written copies of my remarks, if it's okay to share with the committee.
Absolutely.
Thank you. Thank you. Again, my name is Chris Calabrese. I'm the counsel for the ACLU's Technology and Liberty Program. Thank you so much for having me down today. I'd like to take a little of your time to discuss one of the most troubling federal state initiatives that we've seen in recent years, and that would be, of course, the Real ID Act. Let me say up front that the ACLU believes that the entire concept behind the Real ID Act is flawed. Frankly, we think it's a national ID card, and we think that that brings with it all the problems of privacy problems associated with the national ID card. We also think from a practical point of view it is almost completely unworkable, and it will be a nightmare both for you to implement and for the citizens of your state to participate in. Before I talk abstractly or a little abstractly about our problems with the Real ID Act, I just want to let you know sort of concretely what's happened and what I think will give anyone a little bit of pause. Recently, the state of Alabama decided that it was going to begin to attempt to implement the Real ID Act, a small portion of the act, and that was to make sure that the driver's license, the name on every Alabamian's driver's license was the same as the name on their Social Security card. Obviously, in a number of cases, people have gotten married. People prefer to use their middle name. There's plenty of folks whose names don't match up. So Alabama sent letters to approximately 65,000 to 80,000 Alabama citizens, and they started with the folks who had their licenses the longest. So, of course, it was primarily seniors. And they sent them letters saying that they needed to fix their driver's license to make it match up with their Social Security name. And people were, they were terrified, frankly. And it's strange to say that, but, when you evoke Social Security and driver's license, seniors think they're not going to be able to drive and they're not going to get their Social Security checks. And people jammed the DMV. They waited in line for days to get this fixed. One 70-year-old woman finally said on the third day, after she finally got, she'd waited in line for 2 days, she got her license, and then they wanted her to pay the $18 fee to, get a new duplicate license, and in her words, she about hit the roof. This is one small part of Real ID, and I don't think it's a anomalous example of what's going to happen with Real ID. Last year, when state DMV heads were asked for their opinion on Real ID, they described it variously as a nightmare, impossible. There are provisions of the Act that are quite literally, if not impossible, almost inconceivable for DMV heads to implement. And I can talk a little bit about some of those. Before I talk about practical problems, I know this committee is primarily concerned with privacy. So I want to sort of weigh in on that first, and then we can talk, practical stuff a little later on. As I said before, this is a national ID card. There's no, I don't think you can honestly say that it's not. I mean, it's standardized information. The card may look different from state to state, but the information will be standardized on it. And probably more importantly, the Real ID Act requires a machine-readable element on the back that is standardized. Whether the Department of Homeland Security has not decided what that element will be yet, but it will likely be a 2D barcode, perhaps a magnetic stripe. And what that will mean is a common machine available throughout the 50 states and certain to be very cheap to provide once it's needed to read licenses across the country, will be able to read the back of the license, collect the information, store it, presumably share it with other machines and databases. So you'll have, with the machine readable element the same, it's effectively a card that will allow you to track people's movements and to know exactly where the holder of that card has been anytime the card has been swiped. Some of the data that's going to be on the card, your name, your digital signature, probably not initially your photograph, but eventually your date of birth, a little physical description, and of course the ubiquitous unique identifying number. And I think it's obvious that we will all have a number when this is all said and done. And it will be unique and it will be on the card.
Mr. Calabrese, if I could, and I don't want to necessarily interrupt your flow.
Of course.
Could you, when you're talking about provisions of Real ID, could you speak to the things, and again, we brought you down as an expert.
Right,
we want to understand where you think the trends might be going. But I want to make sure the committee understands those things that are enumerated and called for in the Act, and those things that might, at some later date, be brought about by that. So I want to understand that distinction.
All right. Well, the Act absolutely requires, and just to take a step back for a moment, the federal government has not come flat out and required all of these things. What they've said is that citizens of states that do not have Real ID compliant licenses will not be able to get on airplanes or enter federal facilities. So it's it's sort of a sidestep around actual federal preemption of driver's license laws, because this is a pretty big stick. And the Act says that a Real ID compliant license shall have on it all of these standard data elements that are basically exist on a license now, with some exceptions, probably the biggest being their principal place of address. Many states don't actually require your physical address to be on the license. And that, just as an aside, has enormous privacy implications for people like victims of domestic violence, for police officers, for judges, folks who may not want their physical address to be freely bandied about. There's no provision in Real ID to exempt those folks. The Act then requires all of that information to be contained in a machine-readable element on the back, and it requires that all the information in the state's motor vehicle database be shareable with all the other 50 states. So what you have here, of course, is a distributed national database, but essentially one seamless database. From a privacy point of view, those are probably the biggest infrastructure components of the Real ID Act. I'll certain to highlight other pieces as we talk about some of these other things. It's clear that this is going to lead to expanded government use of the license. You already need to show your license to step on a plane. They've talked about it for trains. If this license is freely shareable and savable, what you're going to have is a detailed record of everyone's movements. And, of course, if you need a Real ID to get on a plane or a train, it's going to be a control on your movements. Folks who don't have this license are going to have a difficult time traveling. It's going to be, incidentally, an identity thief's dream. Everyone else's nightmare, but an identity thief's dream. Because this distributed national database will contain in it not only all the information that's on your license now, but a scanned copy of your birth certificate, your social security number.
Mr. Calabrese, you said it will, by the Act, have a scanned copy of the birth certificate?
The Act requires that the information you use to get a Real ID, you'll need 4 pieces of documentation, including a birth certificate or some other proof of your birth date, something that proves that you are in the United States legally or were born here. So typically either a birth certificate or INS documents that show that, and some kind of proof of your physical address, where you're. And all those documents have to be scanned. and saved. So they'll literally be electronically scanned and saved. It'll be part of the database because it'll be part of your driver's license information.
Okay.
And then
On the specifically, and Representative Hill kind of bent over and asked me, specific to this committee, and again, I want to
Sure,
make sure
of
we're
course.
laser
Yes.
focused here. In terms of biological information,
Right.
I've heard a lot of banter about in the press, different folks standing up saying we need this, or other folks saying no, we need that. Is there anything provided for in the law specifically that calls for a biometric identifier on the ID card?
Thank you, Mr. Chairman. I'm glad you asked that because I've seen that same sort of discussion. And to be very clear, the word biometrics does not appear anywhere in the Real ID Act.
Okay.
What it does require is a digital signature, or excuse me, a digital photograph and a signature, which are of course both biometrics.
Okay.
And a digital photograph specifically is the biometric most likely to be used, for example, with face recognition. Because if you have to, of course, face recognition requires primarily to work as a biometric that it be taken in very specific conditions. The lighting be the same, there be the same white background. So a digital photograph is specifically, the specific way that it can be used for face recognition software. And the Department of Homeland Security is already considering in its regulation, at least as we hear, requiring the use of face recognition software in order to sort and see if people have multiple licenses. But that is, of course, a biometric.
Okay.
And I can say with confidence that the Department of Homeland Security believes that they have the authority to require additional biometrics similar to a digital photograph. Perhaps whether they do or not is open to debate. I would suggest that they do. Congress seems to have given them a pretty broad mandate to require what is on the license and what is not. I do not believe, at least as I've heard from DHS, that they will require a fingerprint right now.
Okay.
Nor do I believe that it will have an RFID chip in the license. However, as you see, current U.S. passports are in the process of being issued with RFID chips in them. And I think that you can view that as I wouldn't call it an experiment since it's a U.S. passport, but it will certainly pave the way for the use of RFID chips in other documents, including, I would assume, probably in the next generation of driver's licenses, because RFIDs will have enormous utility for example, collecting a fingerprint, placing in an RFID chip. You can then, in fact, when you scan the RFID chip, bring the thumbprint up off the RFID chip and use it and compare it in a way that you couldn't now with just having a fingerprint on a license, for example. A human being doesn't do a good job of doing that. Representative.
Question about the photograph and the signature. Is that, by the Real ID Act, would that also be required to be saved in the database or scanned or a digital photo and made available to the other 50 states as well?
Yes. The way the Act reads, it requires everything that's in your driver's license database, all driver's license information in the state database. So really, it's actually more expansive than the requirements of the Act itself, because it literally says everything that's in the state database must be shared with other states. So anything that's in your database, and that, I have no idea, and I think most DMV heads would say, are you kidding? That was where we heard that this is impossible line, because of course all 50 states have different IT systems, they have different ways of storing the information, but that's what the Act says on its face, and that's, I would say that was the goal, was to have all this information be integrated and shareable. One thing I haven't touched upon from a privacy point of view is what the private sector is going to do with this information. If you have a standard machine-readable element, it's very likely that when you buy a carton of cigarettes at 7-Eleven, of course they want to see your license to verify your age. It's almost certain that they'll swipe that then, because the technology will be common. So 7-Eleven will be able to buy readers for all of its stores. They'll all be able to read all kinds of licenses, and that information will have a value. It won't, sir.
I'm not sure, but what law? I don't see that in the law. I think that's a rather broad assumption that 7-Eleven will be able to swipe your card. I think there'd have to be legislation requiring that, and I don't see anything like that in the Real ID Act at this point. So, I'm trying to deal with facts here, not broad futuristic assumptions.
I don't believe this is a futuristic assumption. It's legal now. It is not. It has to be made illegal to protect the information on the back of a license.
It'd have to be made legislative to require somebody to swipe it, to show it for age ID, but to require somebody to swipe anything now is not required.
Yeah,
that's what I'm talking about, the requirement.
You could not mandate, for example, If I said to you, if I was a 7-Eleven employee and I said, I'm sorry, I can't sell you those cigarettes because in order to verify that, this is a real license, it's not fraudulent, I'm going to need to swipe it through my machine. There's nothing that says that 7-Eleven has to sell you cigarettes. And if they want to do that, and I would go even further from what we're hearing from DHS.
Actually, I think the ACLU would back me up if 7-Eleven's tried to stop selling me cigarettes if I walked in with a photo ID. So I really don't. I think we're not dealing with the facts of biological privacy here. I think what we're doing is going off on a big scope on all sorts of other privacy rather than dealing with the concept of this committee, which is biological privacy. And that's what I'm trying to get back to.
Sure, I will be happily leave it, except to say that it looks like in the regulations now, DHS is going to either, I don't know what the regulations look, but they're either going to encourage or mandate the swiping of cards to verify that they're not fraudulent. So, if that happens, I think you will then see private sector piggybacking on that information. But we can leave it aside. It's certainly, we've talked a lot about the privacy of this, the privacy implications. Would the committee like to talk a little bit about cost and practical aspects? I don't want to take from the committee's time except to note one number, $11 billion. That is what the National Conference of State Legislatures and the National Governors Association last week estimated that Real ID would cost nationally.
And again, I appreciate your willingness to share and certainly your knowledge, and there may be some offline questions. Yeah. I do want to make sure, to Calvin, Representative Hill's point, that this committee stays focused on the biological, the biometric components of this.
Yes.
This is not a Real ID study committee, as it were.
Right.
So,
though I'll do my best to make it one.
So, again, there's nothing, I want to make sure we're clear for the committee, there's nothing provided for in the Act that prescribes, the Act itself does prescribe a digital photograph and digital signature.
That's correct.
Which are biometrics, but it doesn't require for anything beyond that.
Correct.
But other things could be included if the DHS decided they wanted to do that.
That's correct.
So, that's really a policy decision within the department. Okay.
Yes.
In the interest of time, I'd like to ask for a moment if members of the committee would like to ask some questions.
Sure.
I know there's some that have come up.
Okay. That was my own question there.
Is there a implementation date that the states have to meet for Real ID Act?
Yes. The implementation date is May of 2008. I would say that date is unrealistic. As you know, DHS has not implemented regulations. We don't expect regulations before the election, and I would be surprised. From what we're hearing inside the department, it could be the end of the year, it could be the beginning of next year. One thing I think I'd like to just sort of note so the committee knows it, one of the things that DHS is considering is actually the creation of some sort of separate entity made up of whether state officials and federal officials, similar to the American Association of Motor Vehicles, but with some sort of quasi-official status that would actually create the technical requirements for Real ID. So it's possible that not only will the requirements be sort of kicked further down the road, if you will, but they'll be sort of put in the hands of this entity that's not at all responsive to state and federal concerns, because it's even one level removed beyond the agency. So that is actually a possibility that they're considering. So, to the long answer to a short question, I think it's very unlikely that May 2008 will be the implementation date. And in fact, we think that there's a number of states that are actively resisting implementing the act, and it may in fact never be implemented in its current form. And frankly, that's our hope.
I've got one other question, if I may, and it may or may not deal with the Real ID Act. I read a article just this past week in our local newspaper in Cartersville. I think it was an Associated Press article of I believe it was West Virginia. Several counties in West Virginia, the law enforcement has implemented a new program to where the law enforcement agencies are given an electronic fingerprint reader that wireless transmits the fingerprint data when they basically pull over someone to get positive identification of them. There's also a retinal scan that they use to, I'm seeing some nods, apparently I'm not the only one who read it. Is this a precursor to Real ID, or is this something, I'm just assuming you know something about it, but
I wouldn't want to say it's a precursor, because I don't know what they're going to do, but of course, the technology exists when you build the infrastructure. If in the next generation you built infrastructure with an RFID chip in it, it would be logical to include either a fingerprint, some kind of iris scan, or retina, some kind of more advanced biometric to sort of secure the, more closely link the biometric and identity, and then the technology would then exist, obviously, to do that kind of verification on a much broader scale.
Thank you.
What are other states doing? I know we as a state have had some discussion in the last 2-3 years about biometrics on state ID cards. Can you give us a context nationwide, what other states have done? Who would be using biometrics the most significantly, and who would be less?
It's hard to do. I mean, Georgia was sort of at the forefront in using fingerprints. That's not that common, especially to put them on the license themselves. And then, of course, taking them off the license is again taking I would say a step forward. But others, New Hampshire is probably one of the biggest examples in terms of their concern over Real ID. For example, they have very strict rules regarding what can be on a license and the privacy of driver's license information, more so than the federal law. In general, it's just they have I think they forbid any collection of biometrics. New Hampshire. And they came very close this spring to opting out of the Real ID Act altogether and saying that they believed it was a national ID card and New Hampshire would not be part of it. The governor endorsed that. It passed the House and fell a couple of votes short in the Senate. Another state that's sort of considering this very actively is New Mexico. I was just out there. They obviously have a very different population than Georgia, but many of their concerns were with not just undocumented immigrants, but also, and I think Georgia will have this issue as well, with legal immigrants, because the Real ID Act creates a lot of burdens if you're a legal immigrant in this country. It requires your driver's license be locked into your date of stay, so many people who are here annually on student visas will have to get a new driver's license every year. In terms of keeping the focus on biological privacy, I'm trying to think if there's any state that's done anything particularly interesting. Some states are using face recognition technology routinely in their licenses. Not too many, I believe. I can find out for the committee later on. I can't remember, but I know at least a couple of states are using face recognition technology routinely, and that's probably the most common biometric screening method that's currently in use.
And when you talk about using the technology, you mean just, or you may not know the answer to this question. They're using the technology to take the photos, so the photos that are on the ID cards are able to be used in a facial ID context. But do you know of any implementation?
And then they're routinely using it to make sure, for example, someone's not getting a duplicate license, or not getting more than one license. It's typically, I mean, as the committee knows, it's much harder to do one-to-many matches of a face. In other words, if I have somebody's face and I want to run it against the whole Georgia database, it's hard to do. You get a lot of sort of false hits. one of the things that, but it can be a useful tool for weeding out duplicate licenses or people who try to get, that's one use. What the State Department, for example, is using face recognition technology for is what they call one-to-one matches. So that if I present my RFID-enabled passport to the customs agent, he is going to, my digital photograph is going to be on the RFID, and they are going to take, as I walk up in the customs line, a picture of me. And then they're going to compare the picture that they just took with the picture that's on the RFID as a one-to-one. And again, I would presume that the customs agent might do a better job of that than a computer. But, we've seen, even in one-to-one matching, fairly high error rates. But they seem to think that this adds a level of additional security. So it's something that they're doing. And again, you see these things federally, and then they tend to trickle down. So it wouldn't surprise me if you started to see it in other contexts.
Super. Appreciate that info.
I mean, the passports are a very, very challenging subject. We're really concerned about the use of RFIDs, and I know this committee has, sort of as part of its mandate, the concern over RFIDs. I won't get into a lot of detail except to say that I think it's almost inevitable that if Real ID comes to pass and that it becomes implemented, you'll see RFIDs eventually in driver's licenses. I'm not going to say that that's anywhere but in my sort of, as a watcher of technology and the way these have been implemented. But it's a technology with enormous utility for these kind of tools, but it also is incredibly privacy invasive in terms of tracking, in terms of leaking private information all over the place. So I just think it's worth keeping in the back of your mind that Real ID and the federalizing of these kind of driver's license standards is likely to lead to some kind of RFID compatibility down the road.
No, Representative Cooper, go ahead. Chairman. So I'm hearing from you in the context of a license or an ID card, RFID is a media for storing biometric information.
Absolutely, yeah.
Which I think your concern is centered around it being a media can't turn off, can't turn on, can't turn off, that folks, as you're carrying this ID card around with you that has this biometric information in it, it could be reached out and touched by some entity that's not supposed to touch it, is what you're saying.
Yes, and it makes every entity, makes it easier to be touched in general. I mean, if you, for example, wanted a list of everybody who came into this room for this committee hearing, the easiest thing to do if we all were carrying RFID-enabled documents would simply to put a reader right by the door. And then you just collect the information as people walk in the door. They wouldn't even have to swipe their cards. I mean, that's the kind of data collection you could see routinely. So yeah, I mean, it's illicit uses are certainly large. Its legal uses potentially, I think, are very troubling. I think it's a monitoring of people's movements that's not necessary and can inhibit their desire to get together, to protest, to gather with other people who may be, undesirables, come to ACLU meetings, things like that. So yeah, we're troubled by a lot of what we see with RFIDs.
Mr. Chairman.
Chairman Hill.
As I see it, listening to this discussion and many others on RFIDs, and I share everybody's concern about people reaching out and taking your information. It appears that if technology could be improved so that could be turned on and off, if you will, by some manner for the user that only you could turn it on and off. It might require more biometrics. That might require you putting your thumbprint on a certain part of the card before you wanted somebody to use it. But it appears that the way to solve the RFID problem, because it's going to be out there in many other areas, not just this one, is if technology steps up and we find some way to turn that thing on and off. That might be an answer. That might be the real answer to a lot of these privacy questions. So it can only be utilized when the user wants it utilized. So
the concern, I think, and I don't want to take too much of your time on RFIDs, but the way that RFIDs, there are two kinds of RFIDs. There's active and passive. Active RFIDs, you actually use a battery with the chip. Passive RFIDs are literally just a chip. Their power comes from the reader. So when the reader sends a signal, a radio signal, there's enough energy in that radio signal to charge the chip to the point where it can bounce the signal back. It makes it harder to turn them on and off because they're sort of in a dormant state all the time unless someone activates them. The State Department is having problems with its own chips because even if you encrypt them so that the information on them can't necessarily be read, just the simple method, the simple matter of energizing them and having the chip say, no, you can't read it, provides some information. And obviously, the most obvious being, of course, that it's a U.S. chip or it's a U.S. passport that's bouncing the no back. And, you know, just because they can tell because of the signature of the response that it came from, you know, so I mean, it's just they're starting to have real problems in doing that. I think you're right. I think technology often solves these problems, but RFID technology is sort of exists to be read. I mean, that's the point. So it's hard. You're going very much against the nature of what an RFID is to do this. I'm certainly not going to say it's not possible.
Okay, thank you.
Chairman Cooper.
We talked about New Hampshire wanting to opt out and almost do it. Other than New Hampshire citizens or Georgia citizens being unable to get on a plane or a train, what are the penalties? What are the feds saying?
Well, they would.
Usually it comes with, we won't give you money for something or.
They're saying the other main thing is that you won't be able to access a federal facility, which has in it enormous potential constitutional violations of huge order. For example, if I want to file a federal lawsuit, you're telling me that I can't because I don't have a real ID. You know, if I want to uphold my right to access the federal courts, I can't because I can't actually get into the federal court. I mean, these are real constitutional concerns. But the language is actually much broader. It basically says for any purpose that the Secretary shall designate. So the Secretary can say, and I'm not saying that they are, and I think I've seen this, and I think it's a little overblown, but the Secretary, in theory, could say, you know, to cash a Social Security check, you need a real ID. I think what you'll see more likely is probably to open a bank account, because under the Patriot Act, you need a photo ID to open a bank account now, and it just makes sense to see that turn into a real ID. Just sort of, you can see that logically progressing. But yeah, I mean, and there is there's a 10th Amendment question here that's a little bit beyond the scope of this committee, so I won't take too much time. But I mean, there is a 10th Amendment. It's called the anti-commandeering doctrine, which mandates that the federal government cannot commandeer, if you will, state officials to carry out federal policy. It violates the 10th Amendment. There's a real question about whether this Real ID Act either does, or if it's made increasingly coercive, could turn into that kind of commandeering, where a state has no choice but to employ its own DMV workers, its own people, to issue what is essentially a federal identification document.
I have one more question. This really deals with the security. I'm in the IT business, and I worked with technology in the military. And our philosophy, a few philosophies, and I still hold to one of those, is if you're storing information electronically, it's not a matter of if it will be compromised, it's more of a matter of when. So I do have grave concerns on the amount of information that we're looking at storing from this and other areas. And it brings to the question, and I've made this statement before, and it's one that I think as a government we really need to implement, is the best way to secure data is to not have it, and so only take exactly what you need, and that way you only have to secure it. With this appears to be a pretty broad scope of information that the federal government would require with the Real ID Act. Does the act itself prescribe any type of security that has to be implemented, or minimal security standards for all these 50 states that are going to be sharing information back and forth? Does it even address the protection of the data?
It does not. It addresses two types of security, neither of which is the information technology security. The first is it mandates physical security for the licensing facilities, that they be kept secure, which is actually a very real concern. That identity thieves have been targeting DMVs for a long time because of the value of having a license. If you steal the DMV machines, you steal the DMV laminating codes, and you've got yourself a mill to produce licenses. The other security is it mandates background checks for licensing employees. So everyone who actually issues a license will have to do a background check, which of course raises its own privacy and sort of concerns for folks. But it does not actually mandate the protection of the information that's in the database.
In an information system like this, as being in technology yourself, you know that your highest security is the weakest point of that. And my concern would be here is 50 individual entities to where Georgia might be very secure, Mississippi might be very insecure.
Right.
And if we are openly sharing this data, then Georgia's data, even though within our own state is secured, if we're openly sharing with other states, where systems only as secure as the weakest link.
In the written comments, there's a place called the Center for Democracy and Technology did just a press survey of all the break-ins for DMVs over I think it was 2003, and there were 26 major compromises of DMVs in a single year. To the point that they actually had to shut down the Trenton, New Jersey DMV, fire everybody, and reopen it because they, had become so corrupted, and they were selling licenses, and they were, and you're right, you're absolutely right. And you open up, especially to crooked insiders, and there's always going to be, as a license gets more valuable, the price that people are going to pay to attain such a license is going to go up, and the market is going to exist. So, yes, I think that's a major security concern and a major privacy concern, too, frankly, because it's criminals who want this information.
I think from a state level, that's a concern that I would have. I know that we've made a lot of changes in our driver system here, and I think we're going in the right direction, but if this opens our data up nationwide, then that could circumvent all the efforts that we're making to secure our data.
I think that's true.
Thank you.
Any more questions from the committee? Would you care to share any thoughts on kind of a roadmap for protection of that information? Is there a best practices? Do you know of a state that sees and understands the things we've been talking about and has gone to certain levels to protect information? I know, and again, I'll share with you and with the audience. One of the concerns of the committee, and it's outlined in the House Resolution 1558, is that when we've got a credit card number or a Social Security number, those are numbers that can be wiped clean, and I could get a new Social Security number technically. I can technically get a new credit card number, but I can never get issued a new fingerprint.
Right.
I can never get issued a new DNA set. That's an indelible. That's indelible. It's tied to me for the rest of my life. So when this information is compromised, it's a forever thing. It's not a oops, hey, we'll make this okay and wipe it clean and start over. That's the seriousness of this information. And from a standpoint of whether it's on the tort side in states that have penalties for disclosing information or losing control of it, or a best practices in terms of technology, could you speak to that a little before we wrap up with you here?
It's hard for me to sort of pick out a state that has a best practices, though I'll try to think as I talk. I think that you're absolutely right that the trivial collection of biometrics is one of the biggest privacy problems we'll have going forward. We were talking before, Representative Loudermilk and I, before the hearing about the collection of fingerprints for, accessing your school lunch. I can think of nothing less necessary to have a fingerprint for and more likely to compromise the information. I think that you need to ask, and I'm just going to sort of put this in terms of principles rather than individual states because I can't think of a particular state that does these things, all of them, but you need to determine what, in fact, you are issuing a license for, first of all. What's the purpose? Is it just to drive? In which case, and I don't think that's the case anywhere anymore, but if it is, ask yourself how necessary is any biometric. Of course, people use them for identity purposes now. Make the collection of the biometric be the least invasive possible. In other words, as sure as you are of the person's identity, that should be the point where you keep, for instance, if you believe that it's necessary to lock down a person's information from their birth certificate, from other pieces of documentation that they have, that may be enough. Because frankly, if I walk in with a driver's license, with a birth certificate that says Christopher Calabrese, and a passport that says Christopher Calabrese, and you then enter that information into the DMV computer, having my thumbprint next to it that says Christopher Calabrese doesn't tell you anything if the documents I've presented to you initially are fraudulent. They don't, all you have now is a fraudulent identity with Christopher Calabrese next to it. So ask yourself, well, is there going to be a need for someone to use this document that they presented, this driver's license, with a biometric for something later where they're going to collect a biometric? For example, and I think this would be a terrible idea, but just for an example, if it became routine to collect thumbprints when cashing a check, for example. If that's a use that you want to connect the person's identity and when they write a check that they have the same biometric, then all right, it's at least a legitimate and sensible collection of a biometric for a purpose. If you're not doing that, if it's in fact just sort of an open-ended collection because we might need it later, I guess I would just advise the committee, and I think you all know this, to just think very strongly about not doing that, because it in fact doesn't provide you any additional security, and in fact makes you less secure in terms of your private information and what can be done with it.
I just got to ask him one question. With all of the work that you've done, being an attorney for ACLU and observing what's been happening in our country for the last 10 years and this real ID, do you feel that this moves us closer to what George Orwell warned us of in 1984, that we're moving closer to a police state? Does this take us really further toward that police state that we've been worried about?
I try not to sound as radical as I actually am, Representative. So
just be honest and realistic.
Honestly, I think it does. I think you're creating an infrastructure for control. You're creating an infrastructure to control people's movements. Whether you're controlling them or not, you're creating a physical link between the individual and the information that can be used to track and monitor them. So that's really what a national ID card is. So to the extent that you have that, you can then use it. Whether it will actually be used or not is another question, but in fact the system will be there if it ever is used.
Are there countries that have anything like this or close to this kind of infrastructure?
There are a number of countries, especially in Europe, that have national ID cards. Spain has one. It was very successful in preventing terrorism there. Sorry. Probably the clearest example is Great Britain, which is probably probably 5 years ahead of us in terms of they just had this debate in terms of they're in the process of creating a national ID card, with massive, wide scale, like even more than the Real ID Act in terms of what they're going to collect in terms of biometrics, where they're going to store it. I mean, they're going to register everybody in something like 5 years, at least in theory. Everybody's going to have to go and get their card, and it's all, of course, how you use it. I'm not going to say that Europe is a police state, because I don't think it is. I'm also not going to say that the national ID card has been useful in preventing terrorism there either. So you look at it and you look at what you're trying to accomplish and how far down the road, to a privacy violation a national ID card gets, and you balance that.
Mr. Calabrese, I'd like to welcome you to stay around as long as you can in case you have something to share with other folks as they testify. I'd like to open up. Is there anyone in the audience who has a short comment, remark to make with respect to Real ID that possibly Mr. Calabrese could speak to, or would like to echo some things he said or that you heard from the committee? Again, we're a little ahead of time, so we'll take 4 or 5 minutes. If anyone from the audience wants to speak to the Real ID issue specifically, just stand up in your place. Mr. Calabrese, if there's no further questions from committee, I'd really like to, on behalf of the committee, thank you for coming down.
Thank you so much for having me. I appreciate you taking the time to consider these issues. As you said at the beginning, the thoughtful consideration of what we're trying to accomplish with biometrics and privacy is extraordinarily useful, and it's not just, I guess, in my work, but I see the misapplication of these technologies all the time. So I thank the committee. Thank you very much.
Thank you very much.
Thank you.
We are running about 15 minutes ahead of schedule, so we will, with that in mind, move forward. I don't think there'll be any objection to that. I'd like to call Mr. Brian Luby and Tracy Field, representing the Medical Association of Georgia and the medical industry.
Mr. Chairman, members of the committee, committee specifically asked. Committee specifically asked that we provide information regarding how the HIPAA overlay applies to these issues, and in that regard, Tracy Field from the law firm Arnold Golden Gregory is here to address that issue for you.
And Ms. Field, I appreciate you being here. I will say, before we get too far into this, when we're talking about the medical environment, we're looking as a committee not just at medical practice and medical records, but the broader medical field. I know Mr. Nate Gamble's here from Georgia Hospital Association. We think there might be some issues that GHA wants to stay attuned with, and there might be, and even beyond hospitals to senior care facilities and whatnot. So we're not looking in the testimony today to just narrow it down to medical records, but with respect to the primary concern and GHA wanting to kind of get a feel for where the committee's going, that's going to be the scope today. If you'd like to speak at any point later, we'd like to extend that opportunity to you. So.
Thank you. My name is Tracy Field. I'm a partner in the healthcare practice. Is this on? Yeah. It is on? Okay, I'm sorry. I'm a partner in the healthcare practice, and actually I'm a geneticist before a lawyer, so, and I did clinical research, so a lot of the sensitivity to the privacy issues, and I worked in hospitals. We represent the Nursing Home Association. I'm not here speaking on their behalf at all, but appreciate the opportunity and certainly willing to answer your questions. I worked with the Medical Association and the Nursing Home Association and a group. I am actually the privacy officer for the health plan in our firm, so the privacy issues are everywhere with us. And I thought I would just say a few words about what HIPAA is, because there's some in the privacy rule, if that's appropriate, and then certainly if you have any questions. And I was trying to listen to be sure to address some of the issues that may be relevant for this committee. In 1996, when the privacy rule was passed as part of the Health Insurance Portability and Accountability Act, the human genome was being mapped, and there was a lot of concern about the protection of information that would become more readily available. So with that in mind, and the insurance industry asking for, we want electronic processing of medical information, we want to do billing, we want to take advantage of the web, we need protections in place, privacy and security measures in place. And having worked in a hospital for several years, you used to be able to walk up, hit a kiosk, and you could pull up every bit of information, every piece of privacy, social security number on anybody in the hospital or anywhere. So this was sort of a long time coming. And what the HIPAA rule does, and there were published comments were 52,000 comments when the rule came out. A federal rule, I guess, if you get 1,000 comments, that's extraordinary. 52,000, you can imagine there was a great deal of concern on many sides. And as originally proposed, the law was only, the regulations were only going to address electronic communication of information, and it's now expanded. The privacy rule covers any information that's conveyed to a healthcare provider who transmits electronic billing information. It also protects information that is gathered by a health plan. It also protects information that is used by a healthcare clearinghouse, which is an entity that takes information from a provider, converts it to an electronic format, and then submits a bill. And so all of that information upon your entry into, in the typical scenario I use, and I'm going back to the most common page to be sure we're on the same page. I walk into the doctor's office, I give you my name, address, and phone number. It may be in the phone book, but because I hand it to my doctor for my care, it is now all of a sudden protected information. And it is individually identifiable, and it is now called protected health information. And under the law and under the privacy rule, the physician, the hospital, nursing home, any entity that is a healthcare provider that does electronic billing must therefore take measures to protect that data. They cannot use it for unauthorized purposes. That includes training their work staff. That includes sanctioning employees in the event there is a breach. That includes making sure that you monitor the laws as they change, and it also makes sure that if there are state laws that are stricter and offer greater protections to the privacy, that you consider how that interacts with the federal laws, because that state law could take the place of the federal protections in that case. So a healthcare provider, an insurance plan, all of those entities are regulated, and they have to be very careful in terms of how that information is protected. Speaking to the biometric issues, if you have your picture taken, and people do sometimes for a lot of purposes in the healthcare, that is protected information under the law. What is not protected is tissue, but the analysis of tissue is protected. So it seems a little odd in that regard, because you can take the information, and there was a great debate about that, and I still get my publications from the genetic societies, and they're sort of appalled at that fact, but it is the law. It doesn't seem that it wouldn't be protected. When one thinks about the privacy rule and its protections, and I'll tell you the security rule also comes into play, and you have to make sure that you are, locking your cabinets. You don't have to hide your computer screen so that no one could possibly see. There are certain provisions that walking into a hospital, walking into a nursing home, you may see some information, but you shouldn't see my medical record lying around on the floor. They want to prevent those kind of gross breaches. The security rule, which has recently been in place, that only covers electronic protected information, and that really is pushing more towards the use of electronic medical records and the ability of providers to use the information. One of the biggest things, there was a concern, you want to be able to share information readily between providers. There is something, everybody probably has seen one of those notices of privacy practices. You walk in, you get it, nobody reads it, and you just sort of say, okay, fine. It's not a consent requirement, but there is a provision that's called an authorization. And in the event you want your information to be released for certain purposes, a physician, a covered entity or health plan has to have an authorization. And how that works is, let's say my health plan, I go and have my eyes tested. It for some reason doesn't pay the bill, and we have somebody in my office who helps with processing those claims. Well, she may pick up the phone and call the insurance company and say, why didn't you pay for Tracy's eye exam? And they'll say, who are you? And I can't talk to you. And who is Tracy? They can't even tell them that I'm a member of the plan. What she should do, and what I would do, is say, you may release to this particular individual this information about me in order to process this claim. And that affords them the ability to release information to the benefits person. She carries out her duties. Hopefully I get my claim paid. And then that information, is available for use. It is no longer protected at that point. Authorizations are used in particular as well for workplace, for drug screening, as a condition of employment. Some people, will have to have drug tests done. There can be uses. There can be entities that do that kind of tests and they get those releases. We, tell people perhaps as additional protections to have those releases are good. There can be also on-site work sites where they do drug testing. That's not considered a HIPAA-covered entity because they don't do electronic billing. So the other instance...
Sorry, can I stop you there? You said it's not a HIPAA-protected entity because they don't do electronic billing?
If they're not a provider doing treatment, right.
What protects information if it's not in a electronic data setting with respect to sharing of information?
Well, what protects it is a provider under Medicare participation requirements. If you have more than 10 employees in your practice, you are required to do electronic billing.
Okay. But if you're a small practice, you don't have 10 employees... then I can't construct an example of
No,
that.
no,
but technically there'd be no requirement.
You are not covered under the privacy rule, and what would happen is the state laws that are in place that afford protections, and there are, the constitutional provisions in Georgia, for instance, that would protect that information. But you're right.
Okay.
If I did paper billing and never submitted an electronic claim, but I were a health care provider, I would not be covered by the
But
privacy
there is law
rule.
in Georgia to hang your hat on if you were not electronic billing.
Yeah. The privacy, we've certainly seen a common law right to privacy in your records, and that's basically what people use.
Real quick question while you're on that. How does this authorization affect collection? Is there an issue if you're turning, the medical facility needs to turn over to a collection company? Does the patient sign an authorization as they're being admitted, or how does that work?
Well, that's an interesting question, because what happens is I do a great deal of reimbursement work. I get medical records all the time from my clients, and so I have to write, here, Jane Doe, she had this therapy. I'm what's called a business associate to that covered entity, my hospital, let's say. And by contract, I am agreeing to be bound by several of the provisions. My law firm, we go through training. We have to educate staff. We actually have signs on files that say this is HIPAA, may contain protected information under the privacy rule. We are not subject to enforcement, except we would lose clients in the event we had breaches, and that's typically how the businesses operate. In the notice of privacy practices, there will be, and there's a great deal of consultants, business operations, all of those activities are carried out, billing, collection activities, etc. And those entities, this is how the privacy rule doesn't just affect the providers, but it also reaches out to several other entities, law firms, accountants, consultants, great deal. It also affects clinical research issues in terms of how you can conduct clinical research, how you can conduct research about who your patient population is, how you can serve, who you're serving. There are certain provisions that allow you to do it, but there's at some point, there may be a line at which you have to go, well, wait a minute, now I've crossed into research. I now have to go get an IRB approval, or I have to get a HIPAA release to enable me to use this information for any other purpose.
Thank you.
Is all this information available for subpoena?
Everything for a subpoena. In the event you have a subpoena, there are requirements in the HIPAA rule that talk about required by law or a subpoena. You certainly have some obligations on the covered entity to investigate the validity of the subpoena. There's some dispute actually going on in the state about plaintiffs' lawyers and between the plaintiffs and the defense bar about even talking to expert witnesses about the care of patients and whether subpoenas are needed to do that, or whether you can even get that through discovery, and that's being litigated right now and being heard in the Court of Appeals. But so the answer is you should be able to subpoenas, a warrant, and in fact this is an area that it does get to be a bit troublesome, and I wanted to raise is in the event I'm in the hospital, I witness a crime on the scene, and I see someone leaving, and let's say they were a patient. If I'm a nurse working there, well, technically the fact that, the criminal is a patient is protected information. There is a narrow exception that enables me to tell law enforcement, so-and-so who is I witnessed the crime on the site, this is a description, and you have certain characteristics that you are allowed to convey. But otherwise, and this happens a great deal, if law enforcement comes into a lot of our facilities and they just want to look through medical records, and they may be saying we're after so and so because we think they may have had a certain certain problem. Well, they have to get a warrant, because you can't just come in and take records. And the facilities and the physicians, they face a great deal of that's a difficult situation to say no. And I've certainly, the Health Fraud Control Unit is quite aware, and we have some struggles sometimes. We'll sit across the table and say, we are protecting patient rights. We are regulated. We have the HIPAA laws. We need to do that. You have to get a warrant. We want to cooperate. No one wants to see those sorts of instances occur, but there's a very narrow exception, and I think there's some law enforcement that's like, we need to be able to get in and get the records and stop it right away, and they do have to go through a process.
So with a warrant, you could have access to really anything that's been collected, tissue, data, whatever, test results. Okay.
There are
Go ahead and answer it.
Well, no, there are exceptions required by law. For instance, there's state reporting requirements, child abuse, birth defects, certain of those instances. Where it's required by law, the entity, can make that exception and do those circumstances and reveal information. For instance, a provider may see someone who has an adverse drug reaction. Can they make that report to the FDA so the FDA can carry out its public health mission? Yes. But the law says, what HIPAA says is you can only do what's minimally necessary information. In other words, you can't tell them that if I had an adverse drug reaction, well, I also had an appendectomy 10 years ago. You don't just send the entire chart. You only send the information that's relevant to the inquiry.
Ms. Fields, earlier you mentioned that the tissue is not protected, but the information on the analysis, is that specific in the HIPAA law, or is that just it doesn't cover it?
I actually brought you a copy in the preamble. There is discussion about that the tissue is, and of course the preamble is not the law, but it does specify that the tissue is not protected. And there was a great deal of banter about this, certainly in the genetics community. But the analysis is protected. I sat on an IRB for many years, and there were usually when a patient came in and they were enrolled in a research trial, and how that information is released is if I want to be enrolled in a research trial and I want to be treated as part of that, I have to sign a HIPAA authorization to enable that information to be released to the FDA, to the drug sponsor, et cetera. That's really one of the few times that you can require someone to release their information. And it makes sense because they need that information.
So could your name and other information travel with that tissue?
Absolutely.
Wow, that looks like a loophole. Okay, thank you very much.
But there are, other protections, and we work with. It seems as if there's a loophole, but that there are other parameters you certainly don't want. If people protect that information, there are clinical lab regulations in terms of how that information must be protected that are already in place. So it seems like they should have said it was protected, but it's really. It is sort of it's the analysis that is protected, and there are other provisions. And as I say, I tell a lot of people you may not be per se regulated under that law, but there's a standard of care, frankly, that's just sort of raised the bar for everybody in that regard.
Thank you.
Ms. Phil, I don't want to throw you off. If you've got some more information to present, I'd like to go through that. I do have some questions for you that cover some of the things we've addressed.
Go ahead.
You'd mentioned before conditions of employment. Routinely, as a condition of employment, folks provide urine samples for demonstrating drug use or non-drug use. And I assume some places employers would have access to taking blood if they want to look at existing medical conditions. Is that? I guess where I'm going is from profiling drug use, looking at existing or previous medical conditions, and potentially going beyond that to DNA information. Are there any restrictions within Georgia for purposes of private employment, right-to-work context, where there are limitations on information employers can collect on prospective employees' medical history or medical conditions?
I don't pretend to be an employment lawyer, but I would certainly suspect that if they're discriminatory, you can't take my DNA information to decide that I have a condition that you're not going to cover because that's a condition of employment, and I would say that's probably illegal. Again, I'm not an employment lawyer. However, in those instances where you have, and I think drug testing, et cetera, how that would work is if I want the job, then I have to submit to a drug test, then what I do, I sign an authorization, I get the test, and I authorize the entity that did the test, if they're covered under HIPAA, to release the information to the employer.
So under current law or under case law, it's established that employers should have access to drug use information and can have drug-free workplaces, obviously.
That's my understanding, and again, I'm not as savvy on all the employment nuances in whether you have to do it based on suspicion, but I think that's probably the case. You can condition employment on those sorts of tests. Okay.
Similarly, insurance access to medical information. What access do insurance companies have to someone's? I know I just got for myself and my wife a insurance policy about a year ago, and we had to give a sample to demonstrate no drug use, urine sample, and they took blood to look at existing medical conditions. Of course, they had access to our previous medical records. What is the disclosure? What can insurance companies compel folks to provide as a condition of coverage? Do you have any sense of that?
Well, I can tell you certainly in the HIPAA world, that is life insurance companies, auto insurance companies are not covered entities under the law.
Okay.
Therefore, to release the information to them, what would happen is I decide I want to have life insurance, and as a condition of that, I need HIV testing, drug testing, etc. I would go, and I would also authorize the release of my health information to the life insurance company. The information is protected as long as it was within the provider who gave the care, but as soon as you sign that authorization permitting the information to go to the life insurance company, HIPAA, that no longer regulates how that information is used.
Do you know of any controls within the insurance community that would govern their use of that information that HIPAA wouldn't extend to that?
I'd hate to speculate. Honestly, I don't know. Workers' comp is also not covered under HIPAA. They're out from under it as well. But I don't know. I'm sure they're certainly within the regulatory scheme of the insurance companies, and I apologize. I don't know what the insurance schemes are.
Yeah, we had reached out and would still like to talk to the insurance community on that. Super. Great. Could you speak to that issue at all for us? Just stand up and take. Okay.
I do know that the health information is regulated. If we're talking genetic information, they can't use that. On the life side, is currently not.
I believe there was federal legislation, actually, anti-discrimination on the basis of genetics testing, because there are so many conditions for which you can do screening.
Right.
And I know that there was, but I just don't know the status. I wasn't aware of.
Can you speak to that, Dave? Is it David?
Yeah.
Is there legislation restricting insurance coverage using DNA to make determinations for coverage for insurance? Or is there federal law that speaks to that? I don't think Georgia code does.
On the insurance side, there is.
Okay.
On the life insurance side, and there is not. There are no law to speak to that.
I believe that. I think that's my recollection.
Super. Other members of the committee? I do have one more question. Go ahead, Representative Hill.
Just one question overall, because does HIPAA seem to be working pretty well as a concept in keeping information secure? I know it's cumbersome, and any type of security procedure is going to be cumbersome and probably could be improved. But overall, is it doing a good job to do what it was intended to do?
I think there has been there may have been a pendulum swing to overprotect. And the sad thing is, certainly, sharing information between treating providers was never supposed to be impeded under the HIPAA rules. But that has happened to some degree, and you'll have some facilities, providers who say, no, I need an authorization before I'll even share that. And that's truly not supposed to be happening. I think people are certainly much more aware. I know you walk into a doctor's office now, I think they give you. Our favorite story was you don't have to put a bag over your head because people can know you're a patient of Dr. Jones, but they give you now those beepers to call you back in. I mean, I think there's some extremes, but certainly in regard to people are certainly much more sensitive to it. I think the community always had a sensitivity to, we have a lot of valuable information about people, and I know it's certainly being addressed. We're working with the electronic medical records because, you want people to be cared for and have access to information, but a big issue certainly is protecting that information and making sure. And I think providers, and we're doing everything, and I think my sense is there's a lot of screaming, but they're doing even more than they were before.
Thank you very much.
I don't think so. There are, this is a federal statute. There's civil and criminal penalties, and we certainly have seen one thing that has probably been difficult, I would say, for some providers is it's difficult to understand and make sure you're following the preemption issues with the state laws. And because a lot of areas are sort of contemplated within the federal scheme, when you have a state law that comes up that talks about privacy or protection of records, it's nettlesome. And it's very difficult to go through that, and certainly that doesn't mean it shouldn't happen, but that can cause monkeys to be thrown in the wrench, and I think there's some concerns about that.
I do have one last question. It may not be. You may not want to speak to it. One issue that's come up, and I know there's technology that's available that's been brought to light in the last. It's becoming more more widely known and potentially widely used is, in a medical context, tracking devices, both bracelet types that are fixed outside, and then there's also, I think they're referred to subcutaneous chip implants, very chip things. I know that's been used. Folks laud that, hey, they found my puppy dog and brought him back to me. It's been used for cattle and so forth. I know, and particularly since you have some association with the nursing home association, are there any limitations or any legal issues that have arisen with respect to chips and location sensors with people and in nursing home context? Have you dealt with that with the nursing homes at all? Or?
Oh, well, I mean, there's a huge problem in a lot of nursing homes with people who wander. And so they use wander guards on their bracelet, to sense if they've gone out of a door. And because it's really for the health protection of the and the surveyors will come in and cite you if you're not adequately doing that,
Sure.
and if you're monitoring that. Because of that particular issue. I know I follow FDA law as well, and I know that there's some talk about, the chips issue. What I'm certainly personally involved in is this Georgia Health Information Exchange to try to get electronic medical records so that if you happen to have an accident out of state, it doesn't preclude you're getting good care, and errors in transcription in terms of what are your medication allergies, et cetera. That tends to be where people say, and I know that there's a sensitivity to it. I also know that people will call Barnes & Noble and do it on the web and give them their Social Security number or their American Express card at a heartbeat. But I also know that they expect to be cared for, and they expect not to have errors. And the National Institute of Medicine had this study about the transcription errors, and that's one of the reasons that there is a big push for the electronic medical records and the fact that those records should go with you. In sort of a smart card, I mean, we have providers, insurers in the state who are starting to do that and offering that as a service. And I do have some, certainly, I anecdotally hear people say that they're concerned, but they make a choice in terms of, would I rather be sure that my information is with me and that I have a chance to get good health care? Am I willing to make that, as a compromise potentially? And that's sort of what I think we're at the cusp of struggling with right now, and I think more and more people are thinking it's a good thing that you have information. I mean, I can't tell you the number of cases I've worked on where they run into problems because you can't read somebody's handwriting, or you can't find the paper chart, or you make a copy and you get, denied reimbursement, and then you appeal and they go, well, I couldn't read your records. How can that help you in a
Could
facility?
you speak to the spectrum of media or that can bring folks electronic medical information from cards to a fixed chip to an implanted chip inside of a person? Could you speak to the range of discussion that's in availability?
I know anecdotally people will now go in, you're going to have knee surgery, and they'll tell them, mark your knee. Before you go under, tell me, you put it on a black magic marker and you mark it so that they know. So that's sort of a less sophisticated. I know that we have, and this is a coalition of the hospital, medical, nursing home, pharmacy association, as well as the plans in the state, and the DCH. We've been talking about this. What are the possibilities? A card for the individual to carry so that they can swipe and use their information. There's been some resistance, but I think that people are now coming around more. Blue Cross just announced that that's what they're doing. Kaiser as well. I mean, I think it's sort of, it's amazing. I'll call a hospital here and I'll say I need an appointment. They go, do you live on Lanier Boulevard? Is that still your number? And oh, okay, yes. And it's great because I don't have to go through it, but it does, it's a little bit startling. I haven't seen as many cards. A couple of years ago, we were getting presenters about the cards, and it was the great Bill Gates mistake with the card. He tried to do a demonstration, and it caught on fire. So he came back 2 years later, and he did the demonstration, and it worked this time. So I think there's been a little more trust that it actually will work. But I don't see the cards as much as I do see more of a willingness, and certainly the interoperability issues between hospitals, nursing homes, and the transfer of information, and the new safe harbor protections that enable. It used to be hospitals couldn't give anything to a physician without risking looking as if you're trying to pay for referrals, and now there's an exception for electronic medical records that wasn't there, and I think there's a recognition of greater need for safety issues. The VA hospital has been held up as a great example of what happens when you are able to share information and care for people nationally. And when I was working, VA hospitals were like the worst place you wanted to go. So there's been a great improvement in that regard, and that's really a lot due to that technology.
Have you seen any arguments made, compelling in your mind, that you certainly you have cards, then you have there's discussion, and I read about it in the literature, I read about it in from op-ed pieces to scholarly journals talking about having people's private medical information implanted in a chip that they carry with them, so if they don't have their wallet with them, don't happen to have their card, they still can, their forearm could be scanned, and yep, we've got all your information here, Mrs. Smith. Have you seen any compelling arguments to a necessity for that, or because clearly that raises some privacy concerns?
The implant, I've seen it more written about and theoretized.
Okay.
In theory, how would this work? Or I know that there is some movement that could be a great thing to have it implanted in you, but I just don't hear people saying, that would be a great thing to do. I think they're more worried about sharing it on the other end more as a passive sort of way to.
So from a necessity standpoint, having interoperability and having some means to say, here's my information, and having computer systems talk to each other where they can recognize it and it works, seems to be the real crux, as opposed to it's physically on me attached at all times.
And again, and I'm not a technology expert, but I can tell you what I am told repeatedly is the technology is really not the biggest issue. It's the trust and it's the privacy questions that come up. And that's why the group that we're working with, which does bring all the stakeholders to the table, we're trying to work out a lot of those issues, even just to do a pilot, to have desktop faxing, which isn't even available in every facility, so that you could facilitate a transfer much more readily, not have to go back and forth on the phone 16 times.
Sure.
I think that is a more less obtrusive, perhaps, way that people think that might be you feel like it should be happening, but it's not. And as I understand, the technology is not the issue, but it's really more of these issues in terms of the privacy. There is legislation right now, I know about, because different states have different laws in terms of privacy protections. And if I were hit in California, they may not be able to get records from me from another state if there are different state laws out there, which is typically they have more stringent protections than they do in other states. So that's more. It's more of a cultural issue that seems to be the barrier in my view, anyway.
Super, thank you, Representative Phil.
And Mr. Chairman, I was just going to mention something that actually happened to be part of it today. One of the local hospitals, I requested some records, and they say it takes up to 30 days. And I have an appointment with the doctor in a week that was one of those, and just trying to get those done because they're done physically. They're done with the photocopy machine. And I have over 200 pages of path reports and operative reports. If they could have put that on a little 1 gig, I think it would have been so simple. I could have carried it with me.
Right.
And if they don't have the trust issue to transmit it to another doctor, which is again very capable of doing right now, but at least if they could have put it on a chip, I could have carried it with me. My doctor could have plugged it into his computer and immediately had access to what they need. So I think it's important that we go forward, but with safeguards like that, because for somebody to take 30 days when you need the information for critical information immediately, as you said, you could be in an accident and actually they need it in 5 minutes. We have to have some manner to be able to get this important information out, yet still have security safeguards. And I think that's what we're trying to balance here, is looking at that.
And I would the one comment I would say is there's been a great deal of unfunded mandates, and HIPAA was one. Convert to electronic billing, change your codes, and the provider community has borne the brunt of that without any financial support from the feds or the states in that regard. And that is a difficult. So to say, it sounds great, and there are mechanisms now, and in the new safe harbor, a hospital can donate EMR technology to a physician, but there's a copay obligation of that physician. It's the private community that's doing that. So it's great, and I want it as much, but I also recognize, we're cutting Medicare rates. We're doing all of this on one side, but if you want it also does, in the long run, if we think it's going to save lives, which we do, and if we think it's going to save money, well then there needs to be some funding for that. And we have none right now.
Excellent point.
Any other questions from the committee? Any questions or relevant points to what Ms. Field has presented from anyone in the audience? And again, I appreciate gentleman from the Insurance Commissioner's Office speaking up. Well, Ms. Field, I really appreciate your time today.
Thank you.
I know your time is valuable, and we just wanted to make sure we use it well. If there's any other questions or things that come up relevant that your members or clients would like information on or would like to have spoken to or addressed by the committee, we will have one more meeting.
Okay.
So we'll be available to you, and I appreciate your time again.
I'd be happy to help. Thank you very much.
Thank you very much.
You guys want to take 10? Tell you what, let's. We're running a little ahead. We've got. Is Dr. Warren here? Because we might take 10, or might let some other folks.
He's here early. He was
Okay.
supposed to testify at the end.
Mr. Craig, are you?
Lunch is almost here.
Okay. We've got Mr. Craig from the Georgia Biomedical Partnership. One of the charters of this committee was to make sure we were speaking to the research and development community and embraced any concerns they had in the scope of the study committee. So again, we welcome Mr. Craig, and again, we've got some time. We would welcome your comments.
Thank you.
Turn the mic on there, the top, the little button
Just
up.
make sure it's red up there.
Yeah, red. See the red button on the it's on.
Okay. The documents that I'm passing out there include a series of questions and answers referring to medical research, which is where I'm going to focus my remarks on today. So if you have questions beyond that, please don't hesitate to contact me, and we'll get you answers. I don't intend to read the entire document. I'm going to just make some introductory remarks, if that's okay with the committee. And again, I'm focusing my comments on medical research. My name is Charles Craig. I'm president of the Georgia Biomedical Partnership, and thank you for inviting me to this study committee. The Georgia Biomedical Partnership is a private nonprofit association representing 280 pharmaceutical, biotechnology, and medical device companies, universities, research institutes, government groups, and other related businesses organizations in Georgia. We are also the state affiliate for the Biotechnology Industry Organization, which is the national association representing more than 1,100 biotechnology companies, academic institutions, state biotech centers, and related organizations across the U.S. and in 31 nations. The Georgia Biomedical Partnership applauds the chairman and the members of this study committee for their efforts to protect the confidentiality of Georgians' medical information. The members of our organization strongly support the need to protect the confidentiality of all individually identifiable medical information. Our members worked with BIO to help implement passage of the U.S. Health Insurance Portability and Accountability Act. Since implementation of HIPAA, the privacy of medical information and research has not been an issue. Our members, together with BIO, were very engaged in implementation of HIPAA to make sure that genetic information could not be used to discriminate for the purposes of insurance and employment. In addition, our members worked to ensure that the law preserved patient confidentiality while encouraging the continued research and development of new medicines. There also are federal regulations enforced by the National Institutes of Health and U.S. Food and Drug Administration to protect the safety of individuals and confidentiality of information generated about them during medical research studies. Ensuring privacy while encouraging medical research is essential for Georgia's bioscience industry to continue developing new medicines for improving the health of all Georgians and to continue contributing to the growth of the state's economy. I want to give you some background on Georgia's biomedical industry. It's a rich mix of established multinational companies and startup research and development companies. These companies are world leaders in advanced medical research, developing new treatments and diagnostics for heart diseases, cancer, central nervous system disorders, metabolic disorders, mental illnesses, allergic and respiratory disorders, HIV, and other deadly infections. The Georgia Biomedical Partnership will release the first ever Georgia Life Sciences Industry Report next week. This report identifies more than 252 companies in Georgia. They are primarily pharmaceutical, biotechnology, and medical device, medical instruments, diagnostic laboratories, and blood and organ banks. These companies employ nearly 16,000 people. Estimated total product sales in 2006 are $6.2 billion, an 82% increase since 1997. The growth of Georgia's life sciences industry between 2001 and 2005 has outpaced the rest of the state's economy by a wide margin. The increase is significant both in number of companies and the size of employment. The number of life sciences companies increased by an impressive 38.4% compared to a 10.5% average for all the state's industries during that 5-year period from 2001 to 2005. Employment jumped by 11.2% compared to a 1.6% average for all other industry sectors. Between 2001 and 2005, the life sciences industry added jobs in research and development and in manufacturing. Jobs in life sciences R&D increased 46.5%. The overall size of the life sciences industry employment is significantly larger when adding the number of professionals from government research institutes such as U.S. Centers for Disease Control and Prevention, the biological sciences faculty at state universities, and the professionals at the state's research hospitals. In terms of the number of life sciences professionals employed in both private companies and government institutes, Georgia ranks 15th in the nation. Ernst & Young ranks Georgia 7th in the nation in number of biotechnology companies, up from 11th in 2001. The vast majority of these biotechnology companies are research and development stage companies. The Georgia Biomedical Partnership greatly appreciates the opportunity extended by this committee to provide information on legislative initiatives that directly affect our industry. Our organization endorses the BIO's recommendations for state privacy legislation in the attached document that I gave you. However, as I mentioned, we believe that with the passage of HIPAA and the regulations enforced by the NIH and the FDA, the privacy of medical information in clinical research already is protected in Georgia. And I just want to elaborate on this a little bit further. The regulatory system governing medical research in America today is both comprehensive and complex. Biotechnology and pharmaceutical research is closely regulated by the FDA. For both the public and private sectors, strict national institutional guidelines prescribe how medical research shall be conducted. The research process is carefully monitored to ensure strict patient confidentiality. In addition to obtaining FDA or NIH review, clinical trials also must be approved by institutional review boards in compliance with NIH guidelines and FDA regulations to assure patient safety and confidentiality and confidential treatment of data. So I won't read the BIO's recommendations for state privacy legislation, but as I said, there are a series of questions and answers there that may help the committee. And also, if I may, we have the Georgia Biomedical Partnership has its Life Sciences Summit next week, and I would like to invite the members of the committee to be a guest of the summit, and also of a reception the night before, and this would enable you to meet the bioscience community leaders here in Georgia. So just let me know if you'd like to attend.
Where is it?
It's at the Georgia World Congress Center on October 4th, and there's a reception the night before from 6 to 8 p.m. at the Fox Theater. So just let me know if, I believe we did send invitations, but just let me know if you'd like to attend as our guest.
Are there any questions from members of the committee at this point? I've got a couple myself. Chairman Cooper? No. I did my best to scan through a couple of the items you listed here in your recommendations, and I appreciate you bringing those out. You know, one thing we wanted to do as we kicked this committee off was to have folks advocate positions. What we don't want to have is just folks taking non-committal positions and then we're not really knowing where folks stand. So I appreciate you doing that. I've got a question for you on one of these. It's on page 3. Should privacy legislation address genetic information separately than other medical information? And I confess I've not been able to read that in detail, but I do want to ask you to speak to that issue. One thing we're looking as a committee to address is beyond what I would call pure medical information, which is, you know, in a very, very oversimplified sense, medical history, findings, tests from previous doctor's visits, and so forth, and existing medical conditions which can be spoken to through blood samples and whatnot. Yeah, I do think in the creation of the committee there was a concern that as technology advances, that the power and the great positive potential of DNA information, as that evolves and our ability to understand it improves, that we make sure that it not be used in ways that undermine the issues of privacy, issues of access to care, issues of access to insurance. I don't know if you'd call that medical justice. I don't know what you refer to it as. I do think the committee has contemplated at least considering DNA information for purposes of profiling some future condition as an issue that needs at least careful study and consideration. I do think I think it's certainly worth asking, is a existing medical condition that's been identified by a medical professional in the past, and access of insurance companies, access to employers, access to any number of folks to that information, could conceivably be, I think, and could potentially be looked at as being different than looking at someone's DNA information and see what they have propensities for in the future, not that haven't been recognized to date, but based on someone's inherent genetic makeup, they have a certain propensity to develop in terms of conditions. If the committee were considering or contemplating separating those out and saying genetic DNA information ought to possibly be considered in terms of being protected and limited in terms of who has access to it separately than medical information, would that be in conflict with what you're suggesting, or would that be in step with what you're suggesting?
Well, first let me say that I think that that you're correct about the technology advancing rapidly, and so it's to this committee's credit that it's considering that aspect of things. Mm-hmm. And so the privacy laws should be revisited as this technology advances. I think there's no question about that. But the position here of the Biotechnology Industry Organization and the Georgia Biomedical Partnership is that there really is no difference between genetic information and medical information, and that the genetic information forms a part of the continuum of medical information that is necessary for healthcare professionals to provide comprehensive care across the lifespan of an individual or a family. So I think that one of the revolutionary aspects of the genomics advances is that we are now studying diseases at a molecular level. So therefore that's where disease occurs. Whether or not it's an inherent disease or it's a disease caused by the environment, it still occurs at a genetic level.
Okay.
And the other thing that the scientists have found out, of course, is that your genetic makeup could perhaps make you more susceptible to environmental diseases as well. So I guess the short answer would be that there is no difference between genetic information and medical information.
I guess the crux of the question is, using it for example, but and this is something I think everyone in the room would have an opinion on or would have their own unique perspective of. But if, for example, let's take life insurance, for example. Let's say I graduate high school, graduate college, I'm out in my 20s, and decide, I'm trying to get my finances in order, I'm trying to become a responsible adult, I want to get life insurance and think about my young wife, young kids, and think about the future. And as part of that, let's say at some point in the future, part of the procedural check to are you insurable for life insurance is we take your DNA and we analyze it and see if you have any unique conditions that are out of step with the overall population, recognizing that insurance is typically driven by actuarial numbers, and that certain rare conditions, when looked at across a broad population, have very little impact on cost of coverage. But for an individual that was born with a genetic certainty that a certain condition would exist, that typically is a fatal, the kind of thing you can't recover from. Was I, in fact, born uninsurable? Was I born in a condition that I will never receive life insurance because of my genetic makeup? Has nothing to do with the fact of high-risk behaviors. Has nothing to do with not exercising, eating a high-cholesterol diet. Certainly there are certain genetic propensities towards high cholesterol, certain genetic propensities towards heart disease, but is it possible in the future that based on my genetic profile, I was born into this world in an uninsurable condition? And to that point, I think there's some real concerns with respect to looking at genetic information, which portends what can happen in the future, as distinct from medical information, which is something of my medical history. And I ask that question because I do think this committee contemplates that distinction, and I think it's a profound distinction.
And I'm not an insurance expert, so I don't think I can address that aspect of it. And I think that we've stated that we certainly don't think there should be discrimination based on your genetic makeup.
Okay. Yes, ma'am.
I may comment. Women's insurance rates are different than men's.
Mm-hmm.
That's the genetic distinction. That is regardless of whether you have my DNA. And I think it's sort of one of those factors, and I don't know
Sure.
much about the insurance laws, but there's certain boundaries to discrimination that are permissible, non-permissible.
Right.
I do think that the portability requirements under HIPAA were designed to address certain of those concerns that you have, and I can certainly get y'all information about this genetic discrimination issue. One thing, and I should have raised it before about the tissue question, is blood banks, organ procurement organizations, a lot of these entities have tissue, and a lot of the bioscience industry also uses tissue. The infertility community uses your own tissue to help you, achieve a better outcome with a pregnancy or to achieve a better outcome with cancer therapeutics. So once you start to, if you were to delve into that area, you might be reaching into a far vast community, and that was considered certainly under the federal legislations, and there was a conscious decision not to cross into that. I think I should have commented that that's probably really where the distinction between tissue not being protected, because then you're now touching, can you transplant an organ into another person if it's protected information that tissue is there. So it's perhaps a legal technicality artifact that makes it more complicated, but it does sort of address those concerns.
Okay. Representative Hill.
Yes, thank you very much, Mr. Chairman. And that was kind of my question on tissue, and I think it relates to both of you. And I can definitely see the need for tissue being exempt for, like you said, an organ transplant. Let's make sure we can do it. Again, I would like to, because that tissue out there means your DNA is accessible because it's part of that tissue. And Ms. Fields, you stated there were some very good security concerns outside of HIPAA, and I think at some point I'd like to see if we can find out what those security measures are on tissue, because I think that's a concern, and maybe we don't have them here, but if we could have access to that information.
The FDA regulates tissue, and they are actually actively requiring registration and additional new procedures for that, and there's a more comprehensive plan. There were certain part aspects that were regulated already, and that is expanding, and the tissue community, that is all regulated under and there are protections in place.
Okay, yeah. Sometime maybe we can see if we can access it, Mr. Chairman. I'd be very interested in finding that out. Thank you very much.
Okay, back to what I hear you saying in very simple terms. In the 1800s, practically all you could do for a patient was to tell whether they had a fever or that kind of information that you could get from observation and talking to the patient. And that's what you went on. And then we developed blood tests and urine tests and the kind of tests we did. And as medical knowledge has progressed, really using biomedical techniques is just an advancement of how we're learning to treat patients, right?
Yes, I would.
Even though it seems so, but it's just an expansion of our medical knowledge.
Yes.
And it would seem to me that if the committee was going to look at something, that here again it's talking about not regulating the medical aspect, but perhaps regulating how it can be used outside the medical community, like
yes.
an insurance company, like the chairman brought up, so that as we learn more and discover more, that we can use those findings in perhaps treating those genetic factors that you're predisposed for, or helping you avoid the inevitable by new discoveries and so forth. That's correct?
Yes, yes, that's exactly what I'm saying.
One question I had, and we addressed it briefly with Ms. Field, what I believe within the umbrella of your industry is certain medical devices. I don't know if you represent the firm or the kinds of firms that have that create the devices for ID matching. I know my wife just delivered about 2.5 months ago our most recent edition, and we were in Kennestone Hospital, and they, for the first time, which I thought was a kind of a neat tool in the hospital, the baby has a bracelet, and mama's got a bracelet. And before mom and baby can be discharged from the hospital, they do a scan to make sure that the bracelet on the baby and the bracelet on the mama matches, so that the right baby goes home with the right mama. And all that jived, and we took the child home, and it's obviously a new bundle of joy for us. So there are identity readers that are used in medical context in a bracelet format. I know there's other contexts where that kind of thing is used. I know there's some concerns and some questions certainly that have been raised to me since we initiated this committee from some members of the public about similar devices that can hold and maintain information that are implanted inside of people, whether it's ingested or it's put under the skin. I think most of the ones I've seen are just under the skin. Is that an industry? Is that a part of your constituency, if you will? And do you care to speak to the medical necessity of various media versus implanted versus attached technology?
As far as I know, our members are not involved in these devices for identity.
Okay.
But the devices that our members are making are for treatment purposes. And I think there's a distinction there.
Okay.
So I really don't think I can address that particular issue.
Well, in the context of in a treatment context, could you speak to certain technologies that are being used and what their uses are?
Well, there are devices that are implantable pumps to release insulin, for example.
Sure.
And there's one of the companies here in Georgia has a pill that you swallow, and it takes a picture of your entire intestinal tract. I'm not a physician, so excuse me. But that's another device that I can think of. And there are devices range from contact lenses to prosthetics, I should say, for replacement legs, artificial legs and things. Knees. That's correct, of course. Heart valves. I mean, I guess the list goes on and on, but I'm not familiar with any of our companies that address the particular device you're talking about in terms of the identity of the mother and the baby.
It's not just in a mother baby. It's just, I know there's been, I've read some publications about senior citizens that have chips implanted in them so that if grandma wanders off from the nursing home, they can scan her. Yep, this is Grandma Smith and this is Grandma Jones over here. That's kind of the technology. Yes, ma'am.
I was actually thinking, again, excuse me, but diabetes, people wear alerts all the time, and they
Correct.
think that's a personal choice that they decide I'm going to make that information available because I want to. And I think the implant technology, I mean, there are companies that do those implants, and people make that decision because they'd rather have that than risk not having that information available.
Sure.
Just a different
And I should say, I have read, I don't know if any of our companies are doing it, but I've read about advances in devices where in order for elderly people to stay at home rather than be in a nursing home, there are devices to monitor their systems that could actually then alert the doctor that there's a problem. So.
Yep. Understand. Good. Any other questions for the committee, Chairman?
I just have one, Mr. Chairman. I noticed you mentioned the storage of tissue samples for medical research, and you mentioned the work of the CDC. I wonder why you didn't address stem cell. I know the President has already vetoed the congressional legislation, but you want to talk about stem cell research a little bit?
I guess I didn't address it because I didn't know it was part of this committee's
Well, you
focus.
mentioned tissue samples in your document.
Yes.
It's not
storage.
It's not expressly part of the committee, but if
Do you want to share
there's
your
some
ideas
related
in
issues,
terms
we
of-
can discuss it briefly.
Well, what in particular, I suppose?
Well, just the idea of stem cell research and where we should go as a nation. We know what Congress has done, we know what President Bush's position is, but
Well,
Just wanna-
as it happens, the Georgia Biomedical Partnership just did a poll of Georgians' opinions on stem cell research, and I can share those with you just briefly. I mean, the poll showed that Georgians, and this was a poll of Georgia registered voters, statewide poll, by a 2-to-1 margin favor or support embryonic stem cell research, and by a double-digit margin, but a little bit narrower than 2-to-1, support therapeutic cloning to create new embryonic stem cells. And another interesting finding from the poll was that Georgians, by a 2-to-1 margin, believe that Georgia should not have any more restrictive laws on stem cell research than the federal government. And then another interesting finding was that by a 75%, Georgians felt that Georgians should have access to therapies derived from embryonic stem cell research outside the state, if it were in other states or nations.
Can you share those?
I certainly can. I'd be happy to give you those results.
I'd like to have
findings.
I'd like to ask clarifying. Chairman Hill, go ahead.
And I'd like to clarify, because I want to make sure that what I've heard is believe what the president vetoed was federal funding for
Correct.
this, which means we'll keep if there is any embryonic cell research, we'll keep the federal government out of our business and let it go on in where it should go on. The federal government, as we know, manages to mess up almost everything they touch, it seems like. And if research was to go on and go in the private medical community, where it seems like it should be, and work could go on probably much better, much faster, with much less burdensome regulations. We've seen what HIPAA has done to slow things down, so it would be within the safeguards, and I think that might actually be, rather than slowing down the research, that might actually accelerate it and make it much better. So I'm kind of pleased we're keeping the federal government out of something for once.
But Mr. Craig, I appreciate your time very much today. Glad you came early. It's been, I know you weren't dying to stay around until 4:30 to be heard, so you're certainly welcome to stay for lunch and stay with us. If you can add something later in the presentation, please feel free to do that.
All right, and please don't hesitate to contact me if you have follow-up questions.
We'll do that. Thank you, sir, very much.
Don't forget to share that information on the polling.
That'd be great.
Yes.
I've got 12:10. I'm going to ask my assistant here, are we ready to break for lunch? Or the members committee, do you guys want to do lunch now or just wait till 12:30?
I'd like to run off and come back if you don't mind.
Okay, why don't we take a 10-minute break? Or was it late Friday or I think Friday afternoon we talked, and we're really glad to have him. He's going to come talk about some real scientific insight and experience, some of the DNA questions we had as a group, and it'll just be a resource for us to ask specific questions to kind of separate fact from fiction. That's part of what I've asked him to help us get our hands around. So, Dr. Warren, if you could, I'd appreciate you coming and address the committee.
Thank you, Mr. Chairman. I just have a few introductory remarks. So I'm professor and chairman of human genetics at Emory University School of Medicine. I've been a medical geneticist for 25 years, and I'm currently president of the American Society of Human Genetics, which is the largest professional organization of its kind in the world. So, since the discovery of DNA in 1953 and then the decoding of the genome sequence of humans 50 years later, there's been now, this incredible hope that this insight will change medicine the way we currently do it. The analogy I always like to explain to people is currently physicians operate like firemen. They are called to a problem, they try to put it out. And in the future, we're hoping that physicians will be more like fire wardens, where they're simply watching over everything, educating to prevent disease, and then if something does happen, catch it early enough that it can be alleviated easily. So we can do this because it turns out almost every disease we know of has a genetic component. So there are most common diseases that you all know about have partly genetic components and partly environmental components. And so the idea is if we can identify the variation that we all have, we can determine who might be more predisposed to lung cancer, diabetes, whatever, and conversely, who might not be particularly susceptible. So then people's lifestyles and so forth could be adjusted accordingly to their specific risks. Now, with this kind of knowledge, though, it has raised some concerns in the public, often driven by the media, that such testing could perhaps result in discrimination with employment or insurability, even though there really are very, very few examples of that actually occurring to date. To help alleviate this, the federal government has proposed the Genetic Non-Discrimination Act. This is Senate 307 or H.R. 1227 that passed unanimously in the Senate, now is in the House with 234 sponsors, and hopefully this should pass, if not now, in the next new Congress. But the important thing about this act is that it ensures that an individual's private and personal genetic information cannot be used against them. For example, employers cannot fire someone because they are more likely to develop a genetic disorder than someone else, nor can they require an employee to undergo genetic testing. And under this bill, health insurance companies cannot deny coverage or charge a higher premium to an already healthy individual based solely on this genetic predisposition. And the reason why that's important is because all of these genetic tests never can predict with any certainty whether someone will get a disease. It only comments on a probability. So someone could have a higher risk than the average individual, but no one could say with any certainty they will get sick. And so that is the reason why, in particular, health insurance coverage needs to be protected from this. Interestingly, though, the industry is not particularly interested in this sort of thing. They, and I think it's very telling, and the insurance industry is very good at actuary tables. They're very, very good at probabilities. And this sort of thing is not high up on their radar screen compared to all the other things that people do that vastly increase their risk for problems. So anyway, the hope then is with this legislation, people will not be afraid of genetic testing, and in fact they will go on to realize its potential, reduce disease burden, increase economic productivity, decrease healthcare spending, and provide just generally healthier lifestyles for the citizens. So those are my comments. I'd be glad to answer any questions you might have.
I'll start with the members committee that are here. We've got two key committee members. In fact, Chairman Cooper, who's the chairman of House Health Committee, is not here. She's going to be down as quickly as she can. I certainly want her to have a chance to talk to you. I've got a couple questions. Representative Loudermilk, Representative.
Go ahead.
Go ahead. I'm still formulating.
Okay. And again, Dr. Warren, I'd like to thank you again for being here. Dr. Warren, I enjoyed about a 20-minute conversation last week on the phone before I was called away for an emergency. Appreciate your patience there. I wanted to get at some of in our conversation, we can share it with the committee. And I believe you said you had testified on Capitol Hill on some of these things. Mm-hmm. So I want to kind of tap into your insight of what the feds are doing. Now, we as a committee want to work in concert with what's happening in the federal government. In some cases, if we need statewide protections, we want to do that. In other cases, if a statewide bill would simply muddy the water, we don't want to do that. Or if we need to be more stringent in certain areas, then we would certainly consider that. You talked about, and I think you, just based on your comments, that the base reason for not wanting to be able to discriminate against someone, if you use that term, for purposes of genetic profiling or by virtue of using DNA information, is because there's no direct causality. There are multiple factors that lead to diabetes, heart disease, and whatnot. I use those as examples. In cases where there is a pretty clear genetic link, and we had spoken about that. I don't know some of the conditions that tend to be pretty determinative from a genetic standpoint. Does the federal legislation address those conditions?
Mm-hmm.
Okay.
This is all genetic information.
Okay.
But most of those disorders where there is what we call a single gene disorder, like Huntington's disease, those are extremely rare.
Right.
So, those are not the kind of disorders that really are going to affect large numbers of people. And so I think the legislation, though, while it would cover everything, is really geared towards the common diseases that everybody might encounter.
I know a concern, and we'd voiced it earlier before you were here, was that for those conditions, because they're very rare, they're not, when applied as an impact on a broad population, wouldn't impact the actuarial number significantly. For an individual, if it's got a high morbidity or certainly high medical costs, could have a major impact on them. I just want to get a comfort level and kind of gauge if that stuff would be covered too, because it's not that the legislation we're contemplating would have broad applicability, but it's really more a concern of those few people that it would apply to, making sure they're they're addressed in a way that's consistent with what we'd want. Could you speak to, just to educate the committee and educate the folks that are here, could you give us just some simple numbers we could walk away with in our head? I mean, in terms of correlations, controlling for lifestyle, controlling for other conditions, for things like diabetes, heart disease, other conditions that are studied, what the genetic, I don't know if correlation coefficient is the right term, but what the genetic component of that tends to be. I mean, can you speak to that at all?
Yeah, so the way we think about common diseases now is there's probably going to be maybe 5 or 10 genes, different genes that contribute one's individual risk. And even if you have all of those variant genes that contribute risk, lifestyle and so forth still can contribute a significant amount. But each gene by itself really has very little impact. So we think of things as relative risk. And so that's kind of how many times above the normal population your risk is. So if the average risk of diabetes is 1, having an abnormal gene might give you an abnormal risk of 2. So these are not big effect genes, as we call them, because things like cigarette smoking or things that we know have a much higher impact on health have relative risks of 50 or 60 or higher. So these are individually small risks. That's why individually they can't predict with any certainty whether one will get a disease. Now in the future we hope to identify all the genes that could profile someone's risk, and then combined they might have a relative risk that could be 10, 20-fold, but still the environmental component may be equal to that. So there's still how, of course depending on the disease, but there are lifestyle issues and how one can manage an individual prior to the disease. So there are many drugs you can put somebody on, for example, to manage blood pressure, where they're not sick yet, but if they are going to have a high risk of having hypertension, you can start treating that early before there's any kind of onset of disease. So that's kind of the hope of getting these things understood, is we'll be able to do that.
You're in a field that I feel like is sometimes way over my head, but I appreciate speaking to us in layman's terms today, and takes a little bit to formulate some of the questions that I'm going to have, but it's interesting you brought up hypertension. I was recently taking one of those drugs, and my wife mentioned to me, before you were elected, you never had to have this. So I don't know if that's genetic, but being in a high-stress industry and owning my own business and then running for office, I think I was doomed there. When you're speaking of genetics in here, are we speaking DNA basically? Mm-hmm. Okay, I just want to make sure that the terms that I'm formulating in my mind is what we're talking about. With this DNA, and I hear so much about it, I'm not very knowledgeable other than what I hear in the news, and appreciate the work that you're doing. I think it's very valuable, without a question. But I also hear Orwellian information that we can use with DNA. Can you shed some light on, can with DNA, without knowing the person, can you look at that and tell details of the person, their size, their weight, their hair color, their eye color? I mean, what can we really derive from this DNA information about an individual?
Yeah, so some of the controversy about DNA forensics revolve around those very issues, and the problem is they're not very accurate. So even though DNA can fairly conclusively identify an individual or exclude an individual by comparing them to, say, a crime scene sample, if you have a crime scene sample alone, predicting something like race can never be better than 50% probability. So it's not very good. And then we know, particularly in this country, where we all are kind of mixtures of different backgrounds, that it's very, very hard to predict that sort of thing. In other parts of the world where people are more homogeneous, you can kind of become a little better in terms of predictions. But in this country, it's not very, very good. So at best, we can do is 50% with perhaps race. Other issues like height, weight, we really can't comment on yet.
Okay. So I'm just trying to determine what's science and what's science fiction. And a lot of times with our media today, it's hard to derive what is pure science. But I appreciate that. And on the research that you're doing, and this is just more for my information, I think, is can you also take, let's say, my DNA sample and look at genetics, and from that can you derive, is my hypertension because my mom might have been prone to it, or is it because of lifestyle? I mean, is that something that you can take from the DNA and basically say, okay, the lung cancer is obviously not prone genetically, is more than likely lifestyle issue or something like that?
Well, you can't really separate the two, even for lung cancer. So, I mean, I certainly know people who smoke their whole life and are fine. So genetics also can protect as well as make you susceptible. So even with lung cancer, there is a genetic component as to susceptibility, and that's true for hypertension as well. So you never really could kind of separate what is your genetic risks versus your environmental risks. And by the same token, you can take someone who really has very low genetic risk and put them in an incredibly environment that really is prone to bring on those kind of conditions, and they may get them even if they have a pristine genome, which none of us have. So, we can't really do that. What we could do is kind of determine whether or not, you have inherent risk for hypertension, that no matter what, you would kind of be the kind of person that one would have to watch to make sure that their blood pressure gets monitored and so forth. Or, maybe you don't have those kind of genetic determinants, and maybe hypertension still occurs because of the job you have and so forth.
Okay. So I'm still safe blaming my health problems on my ancestors.
Absolutely.
Is that okay?
It goes either way. That works convenient.
Thank you.
One thing that's not been addressed today, but was really addressed in the previous meeting, and you and I spoke about briefly. We talked on our August 30th meeting about DNA's use in law enforcement contexts, and I wanted to ask some questions. I'm not sure that the audience and folks speaking last time are really as equipped to speak to as you might be. I know when the GBI crime lab folks came in and they spoke to, we look at a DNA signature and we pull just certain parts of that signature out that don't tie to medical conditions. They're more inert or parts of the code, and they're reduced to a numerical number. I don't have my mind around exactly what's being done there, but when you look at someone's genome, can that be consistently reduced to a number or series of numbers where you could that you could actually have a DNA number as opposed to, or is it something unique that you can have to match physical characteristics, or can you have, I guess what I'm getting at is, could you, from a protection of information standpoint, could you get someone's DNA number, scramble it using some code, and then so it's more protected? Or I'm just trying to think through issues of protection of the information. If it can be reduced to a numerical code, could it be scrambled, then better protected? Is that ever been considered? I'm just trying to think of ways of protecting the inherent information.
I mean, the numbers you speak of are really a way of nomenclature for what one sees on a gel by running the DNA out.
Right.
So there's really no way that we currently could envision of altering that in such a way that, we could either change one's profile or hide someone's profile. That's why I think I talked to you on the phone why the O.J. Simpson defense was so brilliant, because they didn't argue the validity of the DNA, they argued the validity of the sample.
Right.
Because, that's what you can argue, is that they didn't collect it or someone planted evidence, but the DNA is pretty much the DNA, and there's really little to argue around that. As far as a number, though, it's not something where you put a sample of blood in a machine and get a number out. I mean, it's really looking at physically aspects of the DNA, and it's just as a way of databasing it easier. They put numbers on it, but the original sample or samples that might be run in the future would always match up.
They would always match. And that was kind of I guess it was kind of inarticulate the way I asked the question, but I mean, if you look at the different parts of my genome, for example, and I'm a 1, 2, 3, 4, 5, 6, 7, 8, and no matter who looked at it, it's repeatable, that anyone that looked at my DNA sequence would see 1, 2, 3, 4, 5, 6, 7, 8 is Representative Setzler. I'm just thinking about if that can be reduced to a numerical combination for a person, and that might be more easily protected. And are there ways, from best practices standpoint, if DNA is being used broadly or being maintained? GBI indicated they only maintain certain parts of folks' sequence in a numerical sequence, that there be certain best practices, mandate, whatever makes sense to protect that. Hey, if you're going to keep this and store it, it shouldn't be stored in the open. It should be stored in a maybe coded way, so it can be decoded, scramble the 1, 2, 3, 4, 5, 6, 7, 8 in a known way, so that anyone hacking into a database and getting access to that would also have to have the code breaking tool to really know my sequence, as it were. Is that a rational discussion to even talk about?
Well, I mean, I think having protections against database infiltration is always a good idea, and something like that that may be sensitive or involve legal actions are always good to have that kind of protection. In reality, though, it would still be hard to kind of alter, other than altering the actual numbers that are in the database, like you could alter someone's name.
Yeah.
But the actual DNA that those numbers describe
is what it is.
You can't change
it, really. Absolutely. I'm just thinking from a security standpoint, as this information becomes more ubiquitous and we have more of it on more people, if we think about, we're going to look at what's really necessary to collect. If we believe this is necessary to collect, then how can we safeguard what we have? Because, again, we spoke before you got here, there's always concerns. Yeah, there's always this supposed hacker that can come in from the outside, but in many cases it's bad actors on the inside that can make that available to people. And because we as a state are in the DNA information storage business, we're there, we're going to continue to be there. I think there are very strong cases we need to be there with respect to convicted felons or incarcerated felons running against previous unsolved crime information. There's an appropriate context for that, but as we store that and as we manage that, what is a best practice for us? And I didn't have any context for thinking that through until you kind of shared that. So,
I might say, the FBI has kind of led the best practice standpoint for forensics. So the regions of the genome that are tested in crime labs are the same exact places in the DNA that the FBI uses and that the military uses. Because these things, besides criminal cases, are also very, very good at mass disaster identification. So at the World Trade Center, there was a huge amount of DNA analyses done, and Hurricane Katrina, there was a huge amount of DNA analyses done to try to identify remains.
True. If I could, and again, Representative Brooks has joined us. I'll ask one more question, then I'll turn it over to other folks in the committee. In terms of process and technology for analyzing and verifying, I know that's something that we spoke to briefly with the GBI. Could you speak to the emerging technology and ability to rapidly and efficiently look at someone's DNA at a string and say and reduce it to whatever the code is to define the thing to look at a sample from someone? Right now it's a fairly detailed lab process to reduce that to a numerical sequence. What are the emerging technologies moving forward that could do that more efficiently?
I think the science fiction view of that is trying to get something that could go to a crime scene and actually determine that, and that isn't even close to the drawing boards yet. So everything pretty much is going to be a version of what it currently is. It might be a little faster. Certainly the backlog that crime labs have is not necessarily acceptable. So they could use some help with that aspect, but I mean, it's not going to get down, at least in any obvious fashion in the near future, to a portable device or anything like that.
What is the process now? Can you, in 30 seconds, kind of tell us how they do it?
Yeah, there's a process called polymerase chain reaction that actually its inventor won the Nobel Prize about 10 years ago or so. That's because of its simplicity. It just is a way of amplifying little bits of the genome from very small samples to usable amounts. So that's why they can take a single drop of blood, for example, or a single hair, and generate enough product from that to be able to analyze. Then the regions that are amplified are regions that are, like you said, kind of inert parts of the genome, but they are repetitive, so they stutter. So that means that we vary frequently from one another in these regions. And so the numbers often refer to simply how many of a particular base. So DNA is composed of 4 different bases, A, T, C, and G. And there might be 10 T's in a row. I might have 9 T's in a row, you might have 8 T's in a row, and that gives a number. So if they look at a sufficient number of these different places in the genome, they can kind of get then an identity. So in one part of the genome, you and I might have the same number, so that is not informative to distinguish us from one another. But if we look at the entire genome and look at the entire panel, it works quite well. So you can pretty much identify somebody to a probability of one individual versus all of the humans on the planet. So the probability becomes quite strong.
Super. Thank you very much. Members of the committee. Dr. Warren, we had looked at, we had talked before, looking in a number of contexts. I know we've addressed many of those here today. Make sure we can tap into your expertise before you leave. What is the existing research? What's the direction of existing cutting-edge research in the genome? I know we talked about the genome was quote-unquote mapped back in early part of the decade. Where are we now with further fleshing that out, and what does that portend for the next 10, 20 years?
Well, I mean, the hope is that we can take large numbers of individuals. For example, my group, we're looking at schizophrenia right now and taking 500 individuals with schizophrenia and 500 individuals who are free of psychiatric disease and simply comparing their genomes to ask now, is there a variant that is either more common among the schizophrenics or more common among the normal individuals, to try to identify variation that might predispose towards schizophrenia. The value of that is several fold. One is that it often gives us a target for a drug. So if it is a particular gene and we know what protein is made, one might be able to target a drug to that and come up with an effective therapy. It also could give you a genetic test to run if you suspect someone early on, where sometimes the diagnosis of schizophrenia is difficult. That might contribute to that sort of thing. It could also, people who have relatives with certain diseases then are concerned about their future children and so forth, and they could find out whether they carry such a variant even though they themselves are normal, and if they don't carry it, they have no reason to be concerned about it. So a lot of what genetics does in terms of reproductive health is really to alleviate a lot of concerns. When I started in this business, a lot of people forego having children because they had a relative with a genetic disease and no one quite knew what the likelihood of they having a child nor how to test for that. Now we can do that. So a lot of times what we do is we can test and tell people they have no greater risk than anybody else in the population. That's where I think this research is going with a variety of diseases like heart disease, diabetes, and also drug efficacy, drug adverse reactions. So there's a tremendous burden on the healthcare system by people taking drugs that react poorly to that drug. And we don't know why that is, because most of the time the drug works quite well and actually helps people a great deal. But in rare individuals, it can make them quite sick, sometimes sicker than the reason they took the drug. And one of the great pushes now is trying to understand the genetics behind that, because we think that is really a strong genetic component to drug adverse reactions. And if we can understand that, it would be a simple matter of testing someone prior to prescribing the drug and knowing then if that's not the appropriate drug to give them and try an alternative.
We had spoken to the biomedical partnership right before lunch, and we talked about some things in private business, research-wise, and from an institutional setting in terms of R&D, what controls are in place with personal information? If someone came in, whether it's a student, whether it's an adult from nearby campus that's just a big supporter of your program, and they participate in a study, deliver sample, you take a DNA sample, and whether it's schizophrenic or whether it's someone in a control population, what's the process of and controls to safeguard that information? And just using Emory as an example.
Sure, we work under HIPAA regulations for that, even if it is volunteer for a study.
Okay.
And they undergo informed consent, and they're explained they don't have to participate. If they do participate, they can kind of elect to not participate any longer. They're told how their DNA will not be accessible to others in an identifiable fashion, and if there is identifiable information linked to that DNA, how it's safeguarded, who has access, and so forth. So it is not any different really than the medical record.
Okay. So from a standpoint of, it's not, and I don't want to go too much in the weeds, but in terms of it's maintained in some automated database where there's some protection, firewall protections, but not in an offline system in a separate room. Okay, so there's still some concerns in any setting that an outside source would have access to it, but okay. But you all have embraced HIPAA, although you're not, from a statutory standpoint, held to HIPAA. You've embraced it as a framework for.
It turns out it's easier just to go ahead and kind of use that umbrella, because in cases where you're using patients, they of course would be under HIPAA, and then the controls may not. But
sure, rather
than having samples under different guidelines, it's easier to take the most stringent guidelines, and then everybody's under it.
Okay. I assume. I'm not an attorney either, but if. Just trying to think, you all would be subject to, if there was ever a subpoena of information, you would have to, and a warrant. Have you ever heard of any research setting anywhere that was touched by the legal community where they subpoenaed information that was done as part of a study, that information had to be relinquished? Are there concerns there?
I don't know of that ever happening, but it may have. Generally, that's not too much of a concern. Oftentimes in these studies, we code everything and then do the study. So really, going back then to the individual is impossible.
I see. So it's not linked back to the individual.
That's generally the way you do it. Often, other times it is linked, but those are under safeguards. But it is under presumably subpoena action.
Okay. Super. Any other questions of the committee? Dr. Warren, anything else? I'm going to turn it. I'm going to ask if anyone in the audience. Does anyone in the audience have any questions that have arisen from our discussion for Dr. Warren or any members of the committee? Anyone? Just give you a chance to stand up where you are. Hearing none. Dr. Warren, thank you so much for coming today. We appreciate your time. We're a little behind schedule in spite of having started lunch early. That being said, I'd like to call Mr. John Hevner from the Retail Association. He has a presentation for us, and Mr. Hevner, appreciate you being here with us today.
Chairman Setzler, members of the committee, thank you for having us here today. I'm John Hevner. I am the president of the Georgia Retail Association. The doctor's comments may have been just perfect because it may have delayed us our AV needs just right on time. I'll make a qualifying statement first off. I'm not an expert on RFID, and